SJC-13701, Commonwealth versus Cory Alvarez.
Okay, Attorney Kelly.
May it please the court, Brian Kelly on behalf of Cory Alvarez. We are here before the court in order to challenge the Superior Court and the single justice's affirmance of the Superior Court's order regarding Cory Alvarez's increase in bail that occurred after there was an original termination of bail, $500. The Superior Court, after a motion that was filed by the Commonwealth, increased his bail to $150,000. And that was almost entirely based on a deportation order that had issued by an immigration court after a hearing in October where Mr. Alvarez appears unrepresented. So the question we pose before the court is whether or not the lower court should be able to determine that an increase in bail should be had where there is a deportation order. Now, I know the Commonwealth will say that it wasn't entirely based on the deportation order, but if you read the lower court's opinion, it most certainly is almost entirely on that particular order, that deportation order. So the arguments are threefold here. One is whether or not the bail should increase, or whether or not the statute permits the court to consider the deportation order in an increase in bail, whether or not any court, district court, superior court, should be able to consider a deportation order as a factor under 57 and 58. Just for brevity, I'll refer to it as section 57 and 58. And whether or not my client's equal protection rights were violated by the Superior Court's order.
Can I ask you a question about your statutory argument?
Mm-hmm.
Is your argument, I understood from your brief, and I may be wrong, so correct me if I am, that your argument about the statute was that the only things the judge could consider under Section 57 are the factors that are listed in the statute. In other words, that they are exclusive. So that wouldn't be an argument particular to a deportation order. It would be anything that's not included in the statute. Is that correct?
That was the focus of my argument, certainly, Judge.
Okay, so I'm struggling with that as a general proposition because the statute, I don't think, is read in terms of exclusivity with respect to the factors. And I think just in our common experience, judges consider essentially the totality of the circumstances, which include the enumerated factors, but are not limited to the exclusionary factors. So I'm trying to really drill down on your argument. And so do you think that a deportation order stands on different footing, or are you saying it's just only these factors, and so if it's not in these factors, it can't be considered at all?
Probably the main thrust of the argument is what turns on volitional versus non-volitional conduct. And so certainly the statutory construction argument is there. Like I'm sure you all see these arguments where the legislature has opportunity after opportunity to include this kind of conduct. I think Your Honor might be talking about, and I'd love to hear an example, but we see things all the time in Superior Court and district courts where things happen during the course of a case. Usually what we typically see is, in an increase of bail situation, there might be a violation of the conditions. That's usually the number one reason why bail is increased. Or there's a change in the circumstances that says something to do with the defendant's conduct. They didn't follow the conditions. They picked up a new case. A variety of things that occur during the course of the case. So there's two separate questions here. One is the increase in bail based on the deportation order, and then the consideration of deportation order in the setting of bail.
As
And
a
so-
general proposition, would you agree with the notion that if a change of circumstance increases the likelihood that the person will not appear for trial, that that would permit the judge to increase the amount of bail?
I would only agree with that if it was volitional conduct. To me, that's the linchpin in the issue. I don't disagree that there are things that occur during the course of a case that can change the circumstances. But I think that for me, when I read the statute and I read the Commonwealth's brief, and I looked through all those factors, it screams out to me that this is usually conduct that has something to do with what the defendant did or didn't do.
What about psychiatric illness?
I think that's an interesting issue, Your Honor, because I've dealt with Plymouth County many times, and I've never heard them say.
That's irrelevant whether or not Plymouth County's made this argument in Brockton Superior Court. You're arguing about statutory construction and volitional conduct, and a judge, do you agree, can take into account a history of psychiatric illness in setting bail?
Obviously.
Okay, is that volitional conduct?
I'm split on that, and here's why. Because
Because it doesn't help your argument?
does it?
No, is that why you're split on it? Why?
Mostly because I've dealt with a lot of these kinds of cases, as I know Your Honor has, and the conduct of a person who has that kind of mental health issue is volatile potentially, right? So is it volitional versus non-volitional?
Does someone choose to have paranoid schizophrenia?
Absolutely not, no. But I think that's starkly different from the federal government picking up a person outside of their home and taking them into custody. I think that's a completely different factual analysis. Is it volitional versus non-volitional? If you want to just strike down right down the middle, I think it's difficult for me to argue that, honestly. I do, in all candor. I don't want to avoid your question.
So if we weren't going to adopt a volitional, non-volitional dichotomy, what happens to your argument in terms of interpreting the statute?
The mental health and the examples that the government gives, the mental health and the drug dependency examples, I think are good examples of when a person has something going on in their life that could be considered non-volitional conduct. Where I'm trying to strike a balance here, Your Honor, is where the federal government steps in, another party steps in. Think of it in these terms. The government gives an example of a person avoiding court because, and then their friends drive them off somewhere. And I think that's a bad example. Here's a better hypothetical. What happens when a person doesn't appear in court and it turns out they're in custody or it turns out they're in the hospital? Is that considered, do many courts default that person? They usually do not. And the reason they do not is because they didn't abscond based on their own choice, even though arguably if you're arrested in another place, you could. But many courts will not issue a default in that situation.
But what I hear you essentially arguing is for a fact-based, individualized determination.
You could
because you're saying, look at the circumstances. If this person is in the hospital, if this person is drug dependent, if this, and frankly, that makes sense to me. I think that reading is consistent with what the statute is calling for. But that then just gets you into, did the judge abuse his discretion in this case?
Or is there an error of law? I think those are the two
Right, but
points.
so far, what I'm hearing you say is that the error of law would be not drawing this voluntary, involuntary line in terms of interpreting the statute.
Yes, I agree with that. Yes.
Okay.
I believe, and when I read the statute, considering this in this situation is inconsistent with the spirit of the statute.
Why shouldn't we just look at the words of the statute that talk about not whether or not the person is going to flee, but whether or not the person's going to appear in court?
And that's right directly from the case law, Judge, and I don't disagree. But when you dig deeper about what the factors are when you consider that question, they largely are all volitional conduct. And aside from what Justice Garziano has raised here regarding the mental health issues, which I think are good issues but different, it mostly deals with.
But isn't that just because that's what the usual situation is? I mean, here we have a different situation.
I think it's what the legislature intended, is what I would suggest to Your Honor, is that what the legislature intended is that we know that deportation has been an issue, right? It's not as if the legislature was not aware of this. I mean, they've had opportunity after opportunity to make that, if they wanted that to be a consideration, they certainly could have armed the Superior Court judges and District Court judges with that consideration, and they chose not to. So I think that seems to me a glaring omission in the statute, that the legislature didn't write, okay, you can consider this deportation issue as a factor. And I think that's important. And the one case that we were able to find is this New Jersey State Supreme Court case, which is cited pretty liberally because it's one of the cases that we could find that is right on point. It's a 2021 case. And I tried to sort of point out the important similarities in that statute and point out the case was very similar. And that state Supreme Court sided with our argument here, which is that should not be a consideration.
No, I take your point, and that case does talk about volitional conduct with respect to deportation. But does it go back to a combination of what Justice Wilhogen asked and Chief Justice Budd, in that the words of the statute, which are the governed legislative intent in hopefully most cases, are failure to appear, and then it becomes the question of, when the court enumerated the factors in Section 57, are those exclusive, or can a judge consider totality in non-enumerated factors? And I think you landed with Justice Wilhogen, correct me if I'm wrong, that it's not exclusive.
I'm struggling to think of an example outside the statute, to be quite honest. But I don't have any real authority to say I'm right or the court's wrong. I'm usually, when I'm doing bail arguments, it's the facts and context of the community, defaults, which are obviously conduct the defendant has engaged in, criminal history, which is obviously conduct the defendant is engaged in. Family ties is, arguable. I mean, if I live in Boston, my mom moves to California, that might not be my fault. But I think largely what bothers me, I guess, about this case is that it's completely out of his hands. It's completely out of his hands. He's on his way to court. And, maybe there are circumstances outside of the statute that I'm not just struggling to grab onto that a court can consider in raising the bail. Changes in the circumstances of the case, for instance, facts.
What are we to make of the fact that were you to prevail in this issue, your client would remain in custody, albeit on a different jurisdiction?
I have many questions about how that would exactly occur, because I don't know. It just seems like an abyss that people go into, and they can leave and they can stay. But I do know that given this sort of Hobson's choice, this catch-22 that Mr. Alvarez found himself in, do you want to stay in custody or go home? He chose to go home. And that was the decision he made, albeit he was not represented by counsel, and I think that's clear from the record.
But once he makes that decision, doesn't that run counter to your claim that this is involuntary?
That, to me, is the kind of coercive decision-making that was similar to this court's decision in Norman, which is, there's a 58A in front of the court, and do you want to go back to the House of Correction or wear a GPS? And so I think that Mr. Alvarez was fine when he was released. It was no issue. So he would be happy, I don't know about happy, but he would have been fine with dealing with this case from the community, which is where he was. And just, I see,
Could you address some of the larger issues before you go away, which is the state's interest in prosecuting criminal behavior, the victim's interest in seeing justice done? How do we deal with that in this context? Does it have no role whatsoever in your view? Is it not a factor?
I can't say it's not a factor. I can't say that. I think it's the government's interest 100%. But on the other side of the ledger, should the
So does it somehow penetrate into factors that can be considered then?
in terms of 57 and 58, or just
The person's not going to appear, so the government isn't going to be able to try the case. The victim isn't going to be able to see the case go forward. I'm just trying to get a sense of how that works, and whether it's an appropriate consideration here.
there is potentially a way, I would think, that the Commonwealth could work with the federal government to make sure that Mr. Alvarez remains in the community but comes to court, which would be consistent with the lower court's order. And at some point in their brief, they say that this court should
I'm confused because of the supremacy clause. If the feds decide to remove him, the state's not going to be able to do anything about that.
I don't know if that's always true, Your Honor, because in this case, in this very case, they filed a motion to have a special minimus and to have him brought to court. So it's not always the case that they can't work with the federal government to somehow figure out a way in the future to make sure that if, in fact, they want to prosecute this defendant, but he's out and he's following all the conditions. So
But the Commonwealth's going to stand up and argue. They have worked with the federal government in that the federal government's not going to let him out on the street. They're either going to deport him or, but if the state has him in custody, then they're not. So it just seems like it's a Hobson's choice for both sides.
And I would love to answer that, but at the end of the day, I think the answer has to be that should not fall on Mr. Alvarez and his, what I would suggest to the court is statutory right to be released on bail and not have to answer about these federal and state questions of cooperation. If there's nothing further, I'll rest. Thank you.
Thank you. Okay, Attorney Zanini.
Morning, may it please the court. Jack Zanini for the Commonwealth. With me today is Matt Breyer, who assisted greatly on the brief. All the good things are his, the bad things are mine. The court here is reviewing, I believe, the Superior Court order for an abuse of discretion or error of law. The Superior Court judge was very clear that she made two independent determinations. One took into account the removal order and one did not. So the record appendix sites for her orders are Record Appendix 84 to 86, which is her written bail order. And she said he was an extreme risk of flight on his own due to no family or community ties, no job, the strength of the case, the DNA, the penalty. And then her oral findings are in Record Appendix 205 to 207, where she also assessed risk of flight in two ways, quote, on his own, and then separately, she further found that he was a risk of flight due to the removal order. So I think even if you want to knock out the removal order somehow, not take it into account, you have an underlying determination that is free of an abuse of discretion or error of law. So in a sense, maybe this issue isn't quite ripe, but here we are to address it. The bail statute, Section 57, I mean, there's a lot of different questions here. Section 57 doesn't even mention flight or risk of flight. So that's the Superior Court bail statute. In order to take that into account, then it's either under the common law authority of the court, which the statute cannot limit, or it's because it's in 58 and the court has said, well, you can look at 58 and add some more factors. The point is you can add more factors. The lists in the statute, the statutory enumerations are not exclusive. You can take into account any relevant factor, and that's pretty clear.
Does the list of factors give us an indication of what the relevant factors are? That is, I think opposing counsel's argument is that these lists of factors are volitional activities by the detainee or the arrestee, and I would add that they are about his character. So it's one or the other. It's not some third-party entity might take him out of jurisdiction.
There's no reason why that's excluded. So the language of the
Well,
statute.
no, I guess my question to you is there something about the list that is to be considered that informs what should be considered? Because the list, as I read it, is about volitional acts and characteristics of the defendant.
Well, the answer is necessarily yes. The list in the statute has to be considered and is relevant. And the answer as to whether or not it's limited to volitional conduct is no. And there are.
But that's not the question. Is it limited to volitional conduct and things about the defendant, not things about a third party coming in and taking him away?
And is it only about the defendant? I mean, the severity of the penalty has nothing to do with the defendant.
Well, he committed the crime, right? He's alleged to have committed the crime, so there's a tie to that.
Yes, there is the mere fact of the crime, which is why we're in front of the court, arguing bail. The nature of the offense maybe is about the defendant, because he chose to commit a particular offense, rape of a child with a difference of 10 years, with a 10-year mandatory minimum sentence up to life. Severity of penalty, that's up to the legislature. Defendant has nothing to do with that. He didn't choose the penalty. If he could, it would be 0, and that would be that. So severity of penalty has nothing to do with volition. Mental illness, as Justice Gaziano has nothing
But that is definitely about the characteristic of the defendant.
His characteristics,
Yes.
yes. And the penalty of the crime has nothing to do with his characteristics. It has to do with the legislature's choice. Drug dependency is also non-volitional. The word dependency, which is in the statute, indicates non-volition. It's a dependency. He's not
But
choosing.
it's, again, a characteristic of the defendant.
The characteristic, but it's non-volitional conduct. It's dependency. I would suggest his family ties, to a large extent, are non-volitional. You don't get to choose your family. I mean, you're either born into a big family or a small family. It's not like you chose it. You're a Rockefeller or a pauper. You didn't choose. It's not volitional. Your
But again,
reputation.
it's a characteristic of the defendant. So far of the list that you've gone through, the one that you suggest is neither a characteristic of the defendant or volitional is the legislative determination of the sentence potential for the crime that the defendant committed.
There's other things that are not character. Current bail status. A judge in another case in another jurisdiction chose to set a bail. Current bail status. Nothing to do with his choice. His choice would have been no bail. I'd like to go home now, Your Honor. The judge decided the bail. The reputation in the community, although it's somehow a characteristic of the person, it's other people's opinion and other people's view, reputation in the community. So there are numerous non-volitional characteristics or non-volitional factors that come into play. And again, the statutory list is not exclusive. And what matters here, if you set aside the statute, the common law.
What if it wasn't the federal government that was going to take the defendant away? What if it was some other third party that threatened to do so? Would that be a factor that the judge could consider in setting a higher bail?
So if the men from Mars were to come and threaten to
Well,
take
how
him
about a
away.
hostile witness? Let's keep it on the planet. So a hostile witness who, for whatever reason, has a vendetta, I'm sure you've heard of such cases, against the defendant and is threatening the defendant either with death or just to take him away somewhere. Is that something that could be considered by the judge in setting bail?
Yes.
And what's your authority for that?
common sense. If there is a hit on a person, if there's a contract, and everybody on the street is getting paid money to go get rid of that defendant, who's also potentially a witness, a cooperating witness, whether they like it or not, they get immunity or they decide to flip. And there's a large contract and it's well-known.
Any
Can a
cases
judge
that-
take that
any
into
cases
account?
that hold that?
Sure.
'Cause you'd think that would happen a lot. You think that not be that uncommon? Are there cases that say that's an appropriate bail consideration?
I didn't look for such a case, Your Honor, so I don't know the answer to that question. I mean, the sort of similar thing I'm thinking is people go into witness protection and the government, puts them in a safe place out of the community, away from their home, away from their normally resident, in order to keep them safe. So could a judge do the same? I don't see why not. I don't see why a judge couldn't put that witness in custody and keep the witness safe. But again,
I have a question about the record. I recall, but I want to get a little bit, I want to make sure I understand this correctly. What was the Commonwealth told by the federal government about whether or not they were going to actually deport Mr. Alvarez on a particular date, were he not to be detained pretrial? And how was that communicated?
so it was communicated verbally. I think, one of the ADAs got a phone call that there was a final removal order, and my recollection is that the final removal order, which I hope is in the record, I'd have to check, that it did have a date of October 31st for the actual removal. The execution of the removal was going to be on October 31st, which then, so it wasn't just a removal order, from the judge. There was a removal order in the record entered on September 16th of '24, where the judge said the person's ordered removed and they've waived their appeal based on their admissions and concessions. So that was the 16th of September. In October is when I would characterize it as the warrant for removal. The actual order to execute the removal was issued, and that was for October 31st.
But if I recall from your brief, I thought there was some statement that the Commonwealth was told that the federal government would not deport Mr. Alvarez if he were detained pretrial.
Correct. So we were told.
How was that?
If he's in state custody, if he's actually in custody and not on the street, not at large, then they would essentially voluntarily stay their execution of their order.
And was that how was that reflected in the record? That
think-
fact?
I think ADA's
of the
saying
communication.
may have related to the judge orally, or it may be in the written motion to reconsider, because that's just a verbal communication. However,
Right.
we know it's accurate because they could go pick up that body anytime they want. The United States government can go pick up Mr. Alvarez, take him into custody, and remove him anytime they want, and they have not. They have not because they're respecting right now our custody so that we can proceed with our trial, which is what this court wants, the people of the Commonwealth want, everyone except Mr. Alvarez at this point wants us to go forward with the trial. The federal government wants us to go forward with the trial. They may change their minds, but right now they're deferring to us because we have custody. And I think the habeas that this court, Chief Justice Gantz, Chief Justice Gary came up with, the habeas on its face says we're going to take custody and then we'll return him to the federal government. And during the proceeding for which he's brought out of federal custody into state custody, if he's then retained in state custody, we will return him when the entire proceeding is over. So right now, the U.S. government and the courts that are implementing that HABE and honoring that language in that HABE, the U.S. government is honoring our court's choice to take people into custody in order to carry out the compelling interest of executing our laws and having our trials.
Can you talk a little bit about the New Jersey case, State versus Lopez Carrera?
Yeah, so I have the initial, there were two different New Jersey cases with the same name, and I think one is before they amended their bail statute and one is after. And I'm not that conversant with those cases. I remember reading it yesterday and saying, well, they amended their statute and they changed their ruling, essentially saying, we've amended our statute. So I don't think it's that on point. It's similar to the federal cases where the word flee is in the federal statute, so then the federal government gets all caught up in interpreting, is flee that's in the statute, is that a volitional act for detention purposes or not? And they also get caught up in, well, this is just two branches of the federal government that, you know, the two Department of Justice branches need to get their act together and decide what do you want to do, and let us know. So again, that just all goes back to volition, which I don't think is the critical fact. The critical fact is the language of the statute, as the Chief Justice pointed out, is appearance for trial. And so where the common law and the common interest is appearance for trial. The Karubin case actually says that you can confine people pending trial for, you know, trial and then service of the sentence. The Brannigan case says the purpose of bail, when it's set at an excessive amount, is to assure the presence of the accused at future proceedings. So the language presence is used by the court. The language appearance is used by the court. The point is you want the person to be there, be at the trial. And so if the means of having them at the trial is a custody order, because that's what the federal government's, you know, exercise of their comity and their decision-making is, that you can have the body, but you've got to keep the body in custody, because their view is the person's a safety risk, public safety risk, and they're going to take them into custody if the state doesn't have them in custody. So our compelling interest is get to trial and have the case adjudicated, and this is a fair and reasonable way to do it. He also may be acquitted. If he's acquitted, we don't know. We can only speculate. Maybe that's going to affect his status with the United States government. Go to trial and get acquitted. Because what triggered the removal order in this case, what triggered the detainer, which is in the record, timing-wise, the crime is on the 13th of October, is reported to the police. He's complained against on the 14th of October, and on the 14th of October is the detainer. So it's clear that this case is the precipitating event for the federal immigration action. And perhaps if he's acquitted, the feds will change their mind about his custody and his removal status. So, unless the court has further questions, thank you for your time.
Can I ask one question? Is there a limiting principle to what you're proposing, which is that if there's a risk that a person is going to be deported, then they can, contrary to their right to be released on personal recognizance, they can instead be indefinitely detained pending trial?
Well, again, it goes back to the individualized assessment of each case on its own. So the limiting principle there is it's an individual case-by-case assessment. It's not a categorical determination.
So what are the facts here that you think are relevant that distinguish this from other such, any case where a person is, say, removable?
I think it's so many people are removable, and a far smaller subset actually have an order for removal, and then even fewer have a warrant for an execution date. So I think waiting for that warrant with the actual date on it is maybe waiting too long, because then you get in the situation we have where you have 72 hours to try to get into court and get a custody order. So I think the actual issuance of the removal order is probably where the line would be drawn.
And so in any case with a final order of removal, it's your view that bail could be set intentionally set in an amount greater than the defendant can afford?
Yes.